Hello and welcome back to my channel Courtse. And today once again I am going to discuss about another important legal issue, uh, which is very vital and very vital in the sense it relates to the fundamental right, the question of liberty. Rather, it's an issue of liberty. Now, we all know that it's a social media generation, and and there are various ways and means to update the knowledge, and in most of the cases, even if you are a part of the court proceedings or not the part of the court proceeding, whether there is any court proceedings against you or it is not against you. Now, in generalized sense, we all know if there is an accused, if there is an FIR registered, there is accused is arrested and he is taken in custody, that is remand, and then after the remand is over, he is put through the judicial custody, and that is when you are entitled to file a bail application, and eventually when you are in judicial custody and your application for the bail is either accepted. If it is denied, then obviously the second ladder, if it is a sessions magistrate tribal, then you can proceed for the bail applications in the session, and from the session to the high court to the Supreme Court. That is what the ladder is. And in case of the session tribal case, you apply for the bail in the session, then from there, if it is rejected, to the high court, and then from there it goes to the Supreme Court. That's the ladder in the matter which are session tribal. Be that so, that's not an issue. Issue is when any accused is granted bail, he is put through some conditions. Those conditions are the discretion of the concerned presiding officer if he is a magistrate or the session judge. That is what the discretion is upon him to put the accused to certain conditions. Those conditions are necessary to secure the presence of the accused during the course of the trial. That's the idea behind those conditions. That is the concept behind those conditions. And in several of the conditions, one of the vital conditions, 1 and 2 of the vital conditions are that the accused is released on furnishing the bail, a bail bond or a bail surety, which the quantum of the bail bond or the amount or the surety of the amount is again the discretion of the concerned presiding officer, that is the magistrate if it's a magistrate tribal cases, or in the matter of sessions tribal, it's the sessions judge prerogative and discretion. So what happens if suppose heavy amount is imposed for a bail bond or a surety, then that defeats the very purpose of Constitution of India's Article 21, because it directly relates to the fundamental right. The liberty is again a fundamental right. So if you put certain accused when you are granting him a bail, and if you are putting a stringent conditions of very heavy amount of bail bond or a surety, the very purpose is defeated. That is what has been observed by the Supreme Court in Anand Singh versus State of UP in the very recent judgment. What has transpired here is these accused who happen to be some clerk in some department, and then he faces some criminal prosecution, and eventually it relates to some forgery and fraud. Obviously, after the arrest and the remand and that entire process was over, he applies for the bail when he was put through the judicial custody, and the magistrate eventually grants him the bail, but while granting the bail, he puts him to a very heavy conditions of paying the bail bond, which in this case was more than 10 lakhs rupees. and the surety of the equal amount. So that's what the precise concept. And then which was challenged before the High Court. High Court did not interfere. It says that heavy amount to be imposed, and eventually the issue was carried to the Supreme Court. And then Supreme Court, in its wisdom, observed that the moment you say that a heavy amount or hefty amount of bail bond or surety, that itself defeats the very purpose for which the bail was granted, and it defeats the entire Article 21, which guarantees the fundamental right. Here in this case, the accused was released on the bail on 18th of October 2023, and because he was unable to secure those bail amount and the surety of that cost of 10 lakh, he had to languish in the jail for another, 4, 5 months, 6 if you calculate from October, November, December, January, more than 5-6 months. So despite the accused being granted bail, if he had to still continue or languish in the jail for the want of not paying the heavy bail amount or the bail surety cost, that defeats the very purpose. That's what the observation of the Supreme Court in this judgment. And then taking into consideration of entire facts of the case, the Supreme Court in its wisdom has reduced that 10 lakhs amount to 25,000 bail bond and the surety of the equal amount. So that is the sum and substance of this present issue, which was before the Supreme Court. And the Supreme Court did not interfere into the High Court's order, which had stated that heavy amount to be imposed, because that was not under challenge. What was under challenge is that when the earlier magistrate has granted the bail, he had imposed a condition of 10 lakh bail bond and 10 lakh surety of equal amount. Then thereafter an application for reduction of the bail bond and the surety amount was made, which was again dismissed, and from there it went to the High Court, and from the High Court it was carried to the Supreme Court in SLP. So in series of litigation, ultimately the Supreme Court had to intervene and reduce the bail bond amount and the surety amount from 10 lakhs to 25,000. I guess it was a reasonable one. Having said that, I am amused by the condition of 10 lakhs which was imposed on this accused while granting the bail. At the most, so some reasonable or lenient approach could have been taken there and then itself, which would have made this accused released at that point of time. But having said so, he could not pay that amount, and that's how he had to languish to the jail, into the jail, and ultimately had to be released only after the Supreme Court reduces the surety amount and the bail amount to 25,000 from 10 lakh. So this judgment is very recent one, so I thought of sharing with you guys in this video, and I hope you have liked this video on this related issue, which we very often see, and maybe will be helpful for any of my viewers if it relates to any of the crime which they are facing, and they are pursuing their bail applications concerning to their freedom. So that's how this video has been made. I hope you have liked this video, and I request you guys to keep on watching my videos. I shall be coming back with another video on another topic of the legal aspect. Till then, goodbye and have a nice day. Thank you very much for watching my videos. Thank you. Bye once again.